Good afternoon, good evening to us all. Okay, so I'll take that again. Good morning, good afternoon, good evening to us all from wherever we may be joining, all across Nigeria and across the world. I do thank you all for joining us this afternoon, West African time. My name is Foluke Akimoladun. I'm a maritime lawyer, arbitrator, mediator, and accountant, and I have the pleasure of moderating today's event. Today, we're going to be doing an introduction to maritime arbitration, and this on the auspices of the Chartered Institute of Arbitrators, UK, Nigeria branch. Now, we all know that maritime disputes can be complex. It can be far-ranging from charter party conflicts to cargo claims to ship collisions and demurrage. And it usually requires a fast, expert-led and confidential resolution mechanism. Maritime arbitration is globally recognized for meeting these needs. And as you will see, our stellar panel is made up of maritime experts who are recognized all over the world. Can we all hear me now? Can we hear me, please?
Yes, we can hear you.
Yes, we can hear you, ma.
Can we hear me?
Yes.
Oh, okay. My apologies for that technical. Yeah, thank you for that technical glitch. So without much ado, I have the honor and pleasure of calling on our first speaker for today, Mr. Bodunrin Adewale. Mr. Adewale is a maritime lawyer, arbitrator, and is the president of the Maritime Arbitrators Association of Nigeria, MAN. And he will be taking us into the foundations of maritime arbitration, scope, disputes, and institutions. Mr. Adewale, sir, please, the floor is yours. Thank you.
Thank you very much.
Sir.
Yes, thank you very much, Foluke, for inviting me to talk about the first topic on the foundations of maritime arbitration, scope, disputes, and institutions. Quickly, before I continue, I'd like to draw the attention of our participants to the title of this webinar, which is Introduction to Maritime Arbitration. So that's what it is. And for those of our participants who have had the opportunity to enroll for the CIArb courses, that's the courses of the Chartered Institute of Arbitrators in Introduction to arbitration, domestic or international, membership leading to associate membership, and of course the fellowship, which is the highest accreditation that the institute has to offer. So in this webinar, is not on general commercial arbitration. It's on maritime arbitration, which is a specialized form
leave this place now, sorry.
of dispute resolution. And so with that brief distinction, if you like, we will then go into the foundations of maritime arbitration. Now, for all of us who are familiar with arbitration, we know that without an arbitration clause, there can be no arbitration. But sometimes, of course, as soon as when a dispute occurs, the parties may agree, if you like, to enter into what we call a submission agreement. So the foundation really of any maritime proceeding is the arbitration of clause, or what we in practice call a dispute resolution clause. We call it a dispute resolution clause because it provides for different forms of dispute resolution, negotiation, mediation, and where both fail, then the parties may have recourse to arbitration. So that's why we call it a dispute resolution clause. But at the end of the day, what happens is this: the dispute resolution clause must be a valid dispute resolution clause. It should contain all the elements that would make it valid so that it can trigger the form of dispute resolution that the parties have chosen or agreed to. Very quickly, I would let you know that, well, remind you, if you like, that an arbitration clause does not oust or remove the jurisdiction of the courts. In actual fact, the courts support the entire process of arbitration from the beginning to the end, from the appointment of arbitrators to the enforcement or challenge of the arbitration award. Now, when you look at maritime arbitration, it's a specialism in the sense that under our juridical law, the court that has jurisdiction over maritime matters is the Federal High Court. And so with that brief background, I will then go into the scope of arbitration, because we could talk all day, but I just have to make it as limited as I possibly can. So what kinds of, what's the scope of maritime arbitration? And by scope, we'll also be looking at briefly arbitrability. In arbitration, there's a concept of arbitrability, meaning that not all maritime disputes are arbitrable. But we will start with what it is not. What it is not is that there are certain disputes that are reserved exclusively for the courts. We call them in rem actions. Actions against the vessel and the owners of the vessel, leading to an arrest of a ship. An arbitral tribunal does not have that power under the laws under which we are operating. And the law under which we are operating is the Arbitration and Mediation Act. An arbitral tribunal does not have coercive powers. It cannot order the arrest of a ship. It cannot enforce interim orders or final awards. So we started with what it is not. So we're left with other things that may be arbitrable, depending on the circumstances of every dispute. So for those of us who are familiar with maritime and shipping matters, we have charter party disputes, which you have a charterer, usually between the owner of the vessel and then the charterer, for a rental charge, which must have been agreed, and other terms and conditions. Then you're also familiar with bills of lading relating to carriage of goods on board at sea. And usually bills of lading have endorsed at the back arbitration clauses, which usually foreign arbitration clauses, because it depends on where the cargo is coming from. Then you have shipbuilding and repair contracts. Of course, carriage of goods by sea requires ships to do the transport. And a lot of the time, parties enter into shipbuilding contracts or repair contracts, and disputes may arise from such contracts. Of course, you have marine insurance. Everybody knows that when you carry goods on board a ship, they're expected to be insured. And of course, collisions and salvage. And disputes may arise from these types of contracts. Now, what are the disputes, common disputes? You have demurrage disputes when the ship is at the port and it's attracted demurrage. One party may allege that it was as a result of the negligence of the other party. Charter party, non-payment of hire. It happens a lot of the time, charter party disputes. In fact, there's one in which I'm currently on the tribunal. It's what they call a young contract. It never even took off because the owner was alleging that the charterer never even paid the first tranche of the rental charge. And that's why they are before us. And of course, that led to the termination of the contract by the owner. And that's an example of such a dispute. But in the meantime, the owner, the charterer, had briefed their lawyers, another set of lawyers, to initiate proceedings, an action, in rem action, at the Federal High Court for the arrest of the vessel. Of course, that's not before us, but it's just an illustration that the counsel involved, the lawyers involved, must have known that the tribunal, our tribunal, did not have the power or jurisdiction to order the arrest of the vessel, even though there are other claims for damages before us. So that's a quick illustration of what can happen in the charter-party dispute.
Thank you, sir.
Yes, have I exceeded my time?
Thank you very much, sir. Yes.
I'm so sorry.
Thank you very much, sir, for that. Not a problem, sir. Thank you very much for that overview. And that really does set in play the context within which the discussions on not just maritime arbitration, but the disputes that lead to maritime arbitration happen. And so that takes us nicely into the presentation of our next speaker, Mr. James Clancy. Mr. James Clancy is a full member of the London Maritime Arbitrators Association. He's an international arbitrator and an associate member of 6 Pump Court Chambers, London. He's going to be speaking to us on the international plane with respect to how the London and the unique angle with which maritime disputes are handled internationally, especially under the LMAA. So, Mr. Clancy, the floor is yours, sir.
Thank you very much. I really am honored to have been invited to participate in this webinar. And I think it's an admirable initiative of the Chartered Institute Nigeria branch to hold a webinar on maritime arbitration. I say that partly because, unfortunately, the Chartered Institute headquarters is increasingly neglecting maritime arbitration. It's been dropped from the flagship program on international commercial arbitration, which is held in Oxford every year. By the way, it has also been dropped, I'm sad to say, from the 3-week Africa Arbitration Academy, which is taking place in London at the moment. There's not a single class on maritime arbitration. As far as the Chartered Institute is concerned, part of the effect of this neglect is actually to alienate some of the maritime arbitrators who have played such a part in the Institute. Historically, former presidents of the LMAA have been chairs or presidents of the Chartered Institute. So it's great to see the Nigeria branch taking an interest in maritime arbitration, as it rightly should. It is important because the maritime sector is the most productive sector of international commercial arbitrations worldwide. Just taking the LMAA alone, the LMAA last year saw in excess of 1,700 new cases. That's about double the size of the ICC's caseload across all of its business sectors all over the world. It's really quite peculiar in those circumstances, given the sheer numbers of cases that go to maritime arbitration, that maritime arbitration isn't studied in other sectors because it's obviously getting something right. It's obviously managing to attract parties to resolve their disputes in that way. I would like to focus on the LMAA, but I do need to explain why. I'm sure that you will appreciate that for historical reasons, London remained very important in shipping. But of course, there are plenty of other jurisdictions, plenty of other seats, which historically have also been important for shipping. And in maritime arbitration, Paris, until fairly recent years, was important, particularly for the Francophone community, including, importantly, Francophone West Africa. And in the early part of my career as a solicitor, I actually worked in Paris, and I dealt with quite a few cases for Francophone West Africa, as well as for North African countries, where the Chambre Arbitrale Maritime de Paris was still a significant player. But it tends to be written out these days from the Sino-Comex charterparty form, and London is preferred. Singapore, of course, is on the rise, as I'm sure you appreciate, but Singapore has the disadvantage that its International Arbitration Act is based on the arbitral model law. It does not allow for appeals on points of law, and it has a rather cumbersome procedure for the appointment of arbitrators. It has quite a bit of catching up to do, but there's no doubt that it is catching up. But I'm going to concentrate on the LMAA in the brief time that's available to me, because there's no doubt that it remains the main center for the resolution of maritime disputes. And also because it is the way in which maritime disputes arising in West Africa and Nigeria in particular will find themselves to be resolved. I have dealt with numerous cases involving Nigeria and other West African countries, as many of my colleagues have. And in the LMAA, which is an association of professional arbitrators, we have currently as one of the aspiring full members, High Chief Professor CIArb, who is well known in London, and who I know is also involved in the Maritime Arbitrators Association of Nigeria. But what the message I particularly wanted to get across actually emerges partly from, if I can give you briefly some statistics. The LMAA saw more than 1,700 cases last year, but most of those settle. There were fewer than 500 awards recorded, and of those, only 75 were after hearings. Most LMAA arbitrations are dealt with on documents alone. This means that lawyers from other parts of the world outside London can perfectly well deal with most LMAA arbitrations from their own desks without having to travel. Similarly, arbitrators can be appointed in Nigeria. Nigerian arbitrators can be appointed in LMAA arbitrations. The likelihood that they would have to travel is extremely low. The LMAA terms, given that this is ad hoc arbitration, provide basically a procedural code for the conduct of the arbitration. I don't have any slides, but I do have a prop, which is the little leaflet containing the LMAA terms and procedures. It is worth a look at, and it is really quite user-friendly. the LMAA, not being an institution, has no means to resolve issues that arise in an arbitration. It's for the tribunal to do that. Hence, detailed procedural rules, trying to cover every kind of thing that can go wrong in an arbitration, but also to guide the parties in ways that have been found to be efficient. Finally, I just wanted to commend the speed of LMAA arbitration. As Mr. Adewole said, and indeed Foluke said at the outset, speed can be important in maritime disputes. Under the Arbitration Act in England, it should only take, the default rule is that it should only take 2.5 weeks to constitute a tribunal of 3 arbitrators. Under the LMAA's terms, you can proceed with only the first 2 arbitrators appointed, so long as they don't disagree, and so long as there isn't a hearing. So you can very quickly have a tribunal in place, and that tribunal can very quickly deal with claims, for example, for outstanding hire. It's quick, efficient, and it is cost effective. Anyone anywhere in the world can be appointed as an arbitrator, and anyone anywhere in the world can represent a party. So please, my message is get involved. The LMAA welcomes as well supporting members. Please consider that as well. Thank you.
Thank you very much, Mr. Clancy. And I have the privilege of being a supporting member of the LMAA, and also a member of MAN, so I can tell you that there is a lot of activity in both spaces. So this fits in well with the presentation of our next speaker, Madam Funke Agwo, Senior Advocate of Nigeria. Madam Agwo is a maritime and commercial lawyer and the Vice President of the International Chamber of Commerce Standing Committee on ADR. And she is going to be giving us a practical insight on handling maritime arbitration from the practitioner's point of view. So from the counsels, the expert witnesses, and the parties involved, what are the issues and the considerations that should be taken, that should be noted in preparing for your case, and of course, presenting your case before a maritime arbitration tribunal. Madam Agwo, please, the floor is yours now.
Thank you very much, Foluke. I'm glad to be here. I'm very excited to listen to both Mr. Adewole and Mr. Clancy, particularly Mr. Clancy's comments about the use of maritime arbitration in maritime disputes. As we know, in Nigeria, it's not as we would like it to be. And I'm hoping, and this is timely, and I congratulate the Chartered Institute of Nigeria, of Arbitrators Nigeria branch for spearheading this particular webinar. It seems to have garnered a lot of interest. I'm excited at that. Apart from that hat that you described, I'm also the president of the Nigerian Maritime Law Association. And together with MAN, Bodunri being the president, and Mr. Clancy mentioned High Chief Ike Hirire, we have been talking about how we can synergize and try to see how we can work towards persuading our clients in the maritime space in Nigeria to look to arbitration in the settlement of their disputes. Mr. Bodunri, I know, has been working very hard on that, and I'm hoping that this webinar will be one of the arrow points of ensuring that this does materialize. So as we have said, as you had said at the start, the discussion is really about introduction into maritime arbitration. And what I am meant to be discussing are practical insights into the roles of the arbitrator, counsel, and expert witnesses in maritime arbitration. So really, these are the actors, some of the actors in maritime arbitration. And their roles are not much different from your general commercial arbitration, but maritime arbitration, as we have said, is a specialism, and we require expert knowledge, but especially technical issues. And we find that even in courts, when these disputes are settled, are dealt with in courts, we have to bring in legal experts, and also we need specialist maritime lawyers as counsel to be able to try to persuade the judge as to what decision he should arrive at. And of course, in our jurisdiction, we have a dearth of maritime judges who are versed in maritime law. And so while the Federal High Court is trying to build on this, they're working hard on that. And the association is also trying to help in terms of identifying people who could possibly be made judges in the Admiralty courts in Nigeria. At the same time, it's all a work in progress. So I'm going to be speaking about the roles of the arbitrator, counsel, and expert witnesses. As we all know, the arbitrator also could be arbitrators or also the arbitral tribunal. This is the decision maker. And they are usually described as the
Mrs. Agbo, are you still with us, ma'am? I just want to confirm, am I the only one that can't hear her? Mr. Clancy,
Yes.
can you hear her? Mr. Adewale, can you hear her?
No.
It
No,
looks like
No.
it-
seems to.
I think she's off.
Okay, I think okay, so we'll just give her a few seconds to try and log back in. Okay, so while we're waiting for Madam Agbo to log back in, I'll quickly call upon Mr. Chidi Ilogu, Senior Advocate of Nigeria. He's a maritime practitioner, senior partner, Foundation Chambers, and he'll be highlighting arbitration and jurisdiction clauses in maritime contracts. And so once he has given us his presentation, we'll go back to Mrs. Agbo on the major players in the maritime arbitration space. Sir, you have the floor. Thank you.
Good afternoon. I trust you can hear me. Can you hear me? Yes. Okay.
Yes,
good
sir.
afternoon, ladies and gentlemen. It's a pleasure to be part of this initiative, and I'd like to commend the association and the persons who've spoken so far on the issues that arise in relation to maritime arbitration. As you would imagine, maritime arbitration is deeply rooted in the evolution of international trade and the navigation of seagoing vessels. That constitutes the environment under which maritime arbitration would, as it were, come to play. Now, these various activities in turn generate diverse contracts which govern or dictate the relationship between the parties and the terms of such relationship. Now, every contract has its own nuances, and essentially parties are obliged to conform or abide by the terms of the contract. So in maritime contracts, we've identified what you may call some of the generic contracts: bills of lading, demise charter parties, voyage charter parties, time charter parties, even terminal port authority issues terminal operations, free trade zone issues, all those relate to maritime contracts of one form or the other. Sale and purchase of vessels relate to, have underlying contractual issues that may need to be resolved by arbitration or by intervention of the courts. So we find that in every transaction, parties are required to either enter into a written contract of some form or the other, in which certain terms feature. Two very salient clauses or terms which feature are the arbitration clause and the jurisdiction clause. Now you find that for every transaction, parties have to determine which jurisdiction clause should apply. Now that jurisdiction clause determines whether it's the law of Nigeria or the law of England or any other state party that has to play in the transaction between the parties. Now that clause in itself sometimes not only controls the main contract itself, it also deals with certain salient features such as the arbitration clause. So for every transaction, it's important that you identify which is the governing law. The governing law is what you may call the jurisdictional clause or the jurisdiction clause. Now, the jurisdiction clause sets out the law that may be salient or pertinent to not just this main contract itself, but the arbitration clause itself. Now, the arbitration clause in many instances is treated as a separate agreement on its own. Now, that comes under the doctrine of separability. And where the contract, the law that governs the transaction is deficient in some form or is declared invalid or not applicable, it doesn't stop the arbitration clause from being applicable. That is a principle that has widespread dimension and acceptability in the international trade and operation of various nations. So we find that these two clauses are very instrumental or very pertinent to the interpretation and enforcement of the contract in itself or the arbitration agreement between the parties. Now, I've tried to draw that distinction between the jurisdiction clause being distinct and separate and the arbitration clause in itself being separable from the jurisdiction clause. What that results in is that you may be able to carry on an arbitration even if the contract is declared invalid. That point is very instrumental or very fundamental to the understanding of the way arbitration agreements work. Now, you then find that in some cases, the two are mixed or are treated as one document or one clause, not one document, one clause in the body of the agreement itself. It could be called the law and arbitration clause, which then states that the charter party or the contract will be governed and construed under, for instance, Nigerian law, and any dispute arising or in connection with the contract will be referable to arbitration in Lagos or Abuja or London, as the case may be, and under the relevant Arbitration Act. And therefore, any modification to those contracts or those laws will be applicable to that transaction. That generally is the way the clause is formulated. So we then find that many times contracts will then, let's use the case of arbitration clauses in charter parties. By way of extension, an arbitration clause in a charter party may, by extension, apply to a bill of lading because express words of incorporation have been introduced to make it so that a charter party would prevail or apply to a bill of lading, and that bill of lading would be deemed to be subsumed or made applicable as what you may call a charter party bill. And in that scenario, the arbitration clause in the charter party would extend and be made applicable to the bill of lading. Now, there are various controversies here and there as to the express words, the nature of the contract, the nature of the words that would give specific application to the arbitration clauses. What is important is that if you then have a charter party, which let's take, for instance, a time charter party, the time charter party would have a clause, an arbitration clause and a jurisdiction clause, which by extension could apply to any voyage charter party made pursuant to that time charter party, and applicable to any bill of lading made pursuant to that charter party. So you then find that you may find that there are three parties in an arbitration back to back, one being a charter party holder of the a bill of lading holder who has an interest in maybe goods that were damaged pursuant to a voyage charter party, and then the voyage charter party holder would then have a recourse to the time charter party because that time charter party holder or party is, by extension, the person that may be liable under the contract. So you find that the arbitration clause and the jurisdiction clause play vital roles in many maritime contracts. Now, without wanting to extend the realm of this study to a master class, because these are very intricate elements which can throw parties overboard in terms of being able to arbitrate a matter or fail to arbitrate a matter because they don't qualify as a party who can claim under the charter party or under the bill of lading. So these are some elements that we need to have at the back of our minds when we deal with these various types of contracts. And of course, if you extend it to port terminal operations, if extend it to free trade zone issues, oil and gas cargo and contracts, all of them have salient features, two of which are the jurisdictional clause and the arbitration clause. I think I'll stop here for now because I think I've given sufficient insight into these various clauses and the role they play in determining the relationship between the parties. Thank you. Are you with me?
Sorry, sir, I lost my connection for a minute there.
Okay, I thought I should stop here because we can take some of the other issues.
Sir, can you hear me?
Yes, I can hear you.
Okay.
Yeah.
Yes, please.
So I kind of put a break on my transmission for now.
Okay, thank you very much, sir.
I can expand when we have some questions and continue with the discussion. Thank you.
Thank you very much, sir. So we have gone from the foundations in maritime arbitration, looking at the scope, the institutions. We've gone to the peculiar ways in which maritime arbitrations are handled on the institutional level, both from the Maritime Arbitrators Association of Nigeria and from the London Maritime Arbitrators Association. And Mr. Ilogu, Senior Advocate of Nigeria, has also helped us to understand the peculiar nature of maritime contracts and the complexities and the multiplicity of parties that can arise within a maritime dispute. We'll now be calling on Madam Funke Agbo, Senior Advocate of Nigeria, to walk us through the players, the major players in the maritime space, from the arbitrators to the counsels and expert witnesses, amongst others. Madam Agbo, you have the floor, ma'am. You're muted, ma. You're muted.
All right. Yes, sorry, I was not allowed to unmute at a point because I had to change my device. I was having problems. I'm sorry, I broke off in the middle of my intervention at the earlier stage. So I was talking about the participants. We're supposed to give some practical insights into the roles of some of the major participants in a maritime arbitration process. These are the arbitrator, counsel, and the expert witness, sometimes called the legal expert. And basically, these are parties or participants who are central to the fair, efficient, and specialized resolution of maritime disputes, as we can all appreciate. I think the previous speakers have spoken to how the complexities of maritime disputes and maritime law in general, and also the fact that, and this speaks to the fact that being a specialist, these participants are also specialists. The arbitrator is a specialist, should be a specialist, ought to be a specialist. Counsel ought to be a specialist, and obviously the legal expert is a specialist. So the arbitrator, the first person that I'm going to be speaking of, is the decision maker, is a neutral, independent, impartial person who is going to make the decision. He's going to be listening to the other participants to be able to arrive at that decision, but also his expert knowledge also helps. Expert knowledge in law, in managing the process. He's central to the maritime process, the arbitration process. His practical experience is often very valuable, as I said, legal training and knowledge of maritime law. And sometimes in, like in LMAA disputes and other disputes in other parts of the world, you have arbitrators who are seafarers, who have been ship captains, who are involved in commercial shipping, and also have other sort of technical expertise as in surveys and things like that. Now, the arbitrator is the one who sets and enforces the timetable. You come to the arbitration, he asks you, obviously, counsel is there on both sides. He sets the timetable, how long you're going to need to provide your documents, your pleadings. Sometimes they want to determine whether or not it's going to be a documents only, or there's going to be viva voce hearing at the tribunal. He manages the procedural hearings, issues procedural orders, and deals with interim applications, issues about maybe the jurisdiction and so on. But with maritime arbitration, especially with the kind of dispute resolution clauses that you have in the maritime contracts, some of which have been mentioned, shipping contracts, charter parties, and so on, it already assumes or actually provides that either a sole arbitrator or two arbitrators or three arbitrators, depending on what the parties want. Obviously, there's still party autonomy involved here. And because parties are also aware that they are going to need the specialist people, they generally can't really interfere in the process. Counsel will be able to lead them through it, and the expertise of the arbitrator will help him through it. The arbitrator also is the one who writes the decision. He drafts the reason award. He has to provide clarity, logic, legal accuracy. All of these are critical to the process. He must also ensure that the award that he writes, the decision that he makes, is enforceable. And these are some of the things that counsel, when I get to counsel, sort of look at. They look at the law governing the arbitration, the dispute itself, of the contract, and they then craft how the strategy around which the dispute would be placed before the arbitrator. That's the role of the counsel. But just continuing with the arbitrator, if it's a three-panel arbitral tribunal, you find that the work is divided up amongst the arbitrators. But the conventional wisdom is that the lead arbitrator should not over-delegate, and that everything should be balanced so that they can arrive at a decision that is fair and reasonable and can be defended. So that's as to arbitrators. Now, counsel, they have been described as the architect of the case. They are responsible for guiding their client through the process, crafting persuasive legal submissions, managing evidence, and doing the advocacy during the hearings. If there's a oral hearing, and their skill is very important in identifying the legal and procedural levers that are critical in framing the dispute in a compelling way before the arbitral tribunal. So they advise on the case strategy, and this case strategy will depend on the kind of arbitration it is. If it's an ad hoc arbitration, so definitely then rules of court may apply, and parties might decide that they're going to adopt particular institutions' rules like MAN or LMAA, as the case may be. We all know that the MAN's rules are available for ad hoc procedures, and I think for Nigerian disputants, so to speak, if you have a maritime dispute and you don't want to go to court, or you're persuaded not to go to court, you can always agree and adopt MAN rules in an ad hoc arbitration, choosing your specialist arbitrators or lawyers. And we have so many in Nigeria, and they're available to assist. And they shape how the issues are presented. They draft their statements of claim, defense points of claim, dependent points of claim, the submissions, and all of this should be concise, legally sound, and persuasive. This is the role of the counsel. He also liaises with opposing counsel and the tribunal on case management issues. They have to agree on how they arrive at the procedural, where the arbitrator then issues the notice, what's it called now? It's run out of my head. The procedural
Order.
Anyway,
Procedural timetable.
The timetable, exactly. It just ran out of my head, and all of these are agreed by both parties on both sides. Procedural orders. That's what I was trying to find out. And my experience is that, especially with international arbitrations, legal counsel are very, very, very meticulous. They are very, very well prepared. They prepare their witnesses well in advance, especially if they have expert witnesses. They go through the cases. They expect the witnesses and the parties to understand the entire process. They also expect the witnesses to be fully understand the nature of the case, and they engage with you constantly in a bit to ensure that when it comes to the hearing, that everything goes well. I think one of the things we try to persuade, especially a Nigerian counsel in arbitrations generally, is not to be confrontational, not to apply what they call guerrilla tactics, trying to stop the arbitration from going on. This is something that we see all the time, and we try to discourage, because what you want and what your client wants is a commercial solution to his problem, and which is why maritime arbitration tends to be very, very fast. And it's something that I would urge on our businessmen in Nigeria. Expert witnesses, we call them the specialist interpreters. They are the technical interpreter on technical issues. Maritime law is very technical aspects of it. Even cargo claims, you're talking about surveyors measuring how much damage has been caused. You're talking about, when you're talking about oil and gas type of cargo, all kinds of calculations have to be made and so on. So you need technical experts or in damages, So you need technical experts like accountants, surveyors, ship captains, and things like that, you know. And so these experts, they explain the complex technical and commercial matters to the tribunal. Sometimes you have naval architects, you have marine engineers, you have shipbrokers, you have cargo surveyors, and even accountants for loss valuations. Now, their duty is to the tribunal, not to the party. Each party may obviously counsel would seek legal expertise for their side of the story, but at the end of the day, their duty is to the tribunal and not to the party who pays them. Objectivity is always crucial. I once was before a arbitral tribunal in Oslo at a very, very, very technical arbitration dispute that was being resolved. And I recall I was legal expert, and the tribunal chair asked me, you know, as part of my introduction, that I understood that my role was to the tribunal. And I said, yes, I knew that. And I said that categorically, that I was there to assist the tribunal and not necessarily the party that appointed me. So this is very, very critical. So the expert prepares his reports. He also responds to opposing experts where, so sometimes you have given an opinion on something, the other side responds, and then you sometimes may have to have a rebuttal expert report. And obviously, you may have to give evidence under cross-examination. So those are interesting pieces of information. So the credibility of the expert is very important, their qualifications. And you know, sometimes you have experts, when they get into the box, they just collapse.
Sorry,
yes. Yeah, I'll just
I'm sorry. Okay,
I'll just round up.
much.
Yeah, experts sometimes, you know, so clarity of thought is very important, and that you have your facts and you know, you're able to present clearly, with clarity and with logic to the tribunal. That helps the clients. Thank you very much.
Thank you very, very much, Ma, for walking us through the major players in the maritime arbitration space. So ordinarily, we were supposed to go around the panelists for them to comment on each other's presentations, but because of time, we may not be able to do that. We'll just quickly take on the questions that have been asked in the chat bot by the participants. And Ifoma is asking, please, Ma, can you clarify the role counsels play with respect to drafting or writing the procedural order for direction? Is this the role of the arbitral registrar, or is the role of the arbitral registrar to be dispensed with? I think the first leg of the question is, what role do counsels play in drafting the procedural order, and what role does the arbitral registrar play in the arbitration process?
Well, I think the question really would be that the answer to that is it depends on the tribunal. You have tribunals where the arbitrator, or if it's a sole arbitrator, they would generally want to have an arbitral tribunal, a secretary appointed. They ask your permission, and that goes ahead. They would draft. He would work with the arbitrator to draft the procedural order. And what you find sometimes is that some arbitrators, in my experience, will send his draft of the procedural order to you as counsel and ask you, both sides, to track changes on the procedural order so that everybody is happy with what we arrive at. So he might propose certain things, because sometimes you don't have that procedural order, especially at the first, after the appointment and the arbitral tribunal has been established, has been constituted formally. The first sort of set of documents or first of writings that the arbitrator will put out will be, you know, how much time each side is going to need to do what. So he would prepare that and ask questions, and then arrive at what would be the final procedural order based on what has been agreed. Or he could put down something, and then ask you to add what you think what you prefer, and both sides would agree all of that, and the final draft will be sent to the arbitrator, and he presents the procedural order. So it just depends on the arbitrator.
Quickly on the need for arbitral registrar, since most maritime arbitrations are ad hoc.
Well, the registrar is really to assist the tribunal. So it's if the tribunal requires assistance, they would ask the parties if they had no objection to their appointing a tribunal secretary. Obviously, if it's a very complex dispute, then it would make sense to have an arbitral secretary, tribunal secretary appointed. So it just depends.
Thank you, Ma. Mr. Clancy?
Thank you. Yes, I was interested in that response, and I thought it was important to say that London arbitration procedure is rather different. I have never heard of a registrar or arbitral secretary or administrative secretary being appointed in an LMAA arbitration. The tradition in LMAA arbitration is that the arbitration only involves the tribunal, the parties, and quite often, but not always, their lawyers. There is never, to my knowledge, anyone employed by the tribunal to assist it. That's partly for confidentiality reasons, but it's also the tradition, but it's also the fact, as I was saying earlier, that the LMAA terms are designed to cover all procedural eventualities. So in LMAA arbitration, we don't have procedural orders of the kind that you find in institutional arbitration, where the institutional rules actually require tribunals to make such orders, and the rules themselves are rather vague and open to interpretation. In fact, paragraph 16 of the LMAA terms says applications for direction should not be necessary. So it's a very different context. I thought it important to explain that, especially given that that procedure, the LMAA procedure, is successful. It's something to think about from the point of view of ad hoc arbitrations.
Okay, quickly, sir. There's another question for you, and this is from Professor Olawanyi, Senior Advocate of Nigeria. And the question is, can you please give us a practical insight into how English courts assist maritime arbitration by granting an arrest order pending arbitration? Does the maritime claim have to be filed in order to obtain such an arrest order? Sir, you have 30 seconds to answer this question.
Well, first of all, the English courts in general are very supportive of maritime arbitration, partly because most of the judges in the commercial court have practiced maritime arbitration while they were barristers. As far as arrests of ships are concerned, that is an admiralty court jurisdiction, and arrests are made under the rules of the admiralty court. Ships can be arrested as security for claims in arbitration. But what we more often find in London arbitration is that the arrest has taken place abroad, not infrequently in West Africa.
Thank you very much for making it as short as possible. I'm afraid that that's all we have time for today. Thank you very much, everyone. I would like to now call upon our very own chairperson, Madam Shola Adebomire, to give us her closing remarks.
Thank you very much.
You have an echo, ma. Mrs. Adebomire, we can't hear you.
Yes.
We can hear you now, ma.
Okay. Thank you. I just want to thank everybody, the participants and the panel for this wonderful webinar. And I'm sure everybody can see from the comments, the questions, that this has been really interesting. We have all gained knowledge, and that is the point of these specialist webinars, I want to thank Mr. Clancy, Mr. Ilogu, Mr. Adewale, and Mrs. Agbo. They are all foremost maritime arbitrators, maritime lawyers, and even our own Foluke Akinwoladu, who moderated. I want to say thank you to everybody for attending. From about the first, I think it was 3 minutes, we already had 50 participants in the first 3 minutes. I mean, that really gladdened me that people are really taking these things very seriously. And all those who came in, I don't think maybe one or two people left before the end. So thank you very much. I know that the panelists have put in a lot of work into this panel and this webinar, and I want to thank you all. We're going to continue having specialist webinars like this. It's going to always be on the 3rd Friday of every month. Next month, we're talking about taking the stand. The states are going to be taking the stand, and we're going to be looking at investment treaty and investment disputes. And so that is also promising to be very interesting. We'll be looking at different areas just so that we can widen the scope for our members and even non-members, all those who are interested in arbitration and ADR, just to let people see many other areas. The first one we had last month was on sports. This one is on maritime. Next one, investment. One is coming up on mining. I mean, you'll be surprised that we have a large mining community and mining disputes in Nigeria. And then we're going to have one knowing our neighbors. Not many people know about the OHADA and OHADA arbitration, and mostly our French neighbors, but there's a lot of work in that area. So all we're trying to do is open up spaces and helping all of us to just understand different areas of arbitration and ADR. So once again, I want to thank some of our very senior colleagues who are here, including one of our past chairs, Mrs. Funke Adekoya. Quite a lot of our SCNs are here. I mean, I really, really appreciate, because you encourage even those of us coming behind to know that if at your level you are still looking for knowledge, then what are we doing? We must all be trying to increase our knowledge. So thank you very, very much for coming, and I look forward to seeing you next month, 3rd Friday, taking the stand. Our annual conference is coming up in November, and they've also put in the chat box if there are courses, if you want to attend, you want to become a member of the Chartered Institute, please, the way to join is already in the chat. We're also doing, and this is free, everything is free to add value. People are paying annual subscriptions, want to give value to the subscriptions that you are paying. So all these webinars are free, and we try to bring the best of the best in each industry. So thank you very much to everybody who has attended. Also remember, there's a link to this webinar. So if you want to go back and listen to everything again, we're going to send an email to all those who have participated, or you can go to our YouTube channel and you can watch everything all over again. So once again, thank you very much, and do have a good weekend. Thanks. Foluke, over to you.
Thank you very much, Ma. And then it's Mr. Ilogu. I'm sorry, sir. I can't ask you to speak after the chair has spoken. Thank you very much for your understanding, sir. I do appreciate it. Thank you very much, everyone, for joining us.
Yes, thank you.
Okay, sir. Thank you very much, sir. Thank you very much, sir.
It's not July. It's in July.
Thank you.
I think Madam Chair has said specialist webinars. Oh, bye-bye.
Thank you. Seeing the end. Oh.
But are those charts going? Are the charts going to be there? Yes, she has ended.